All right, good afternoon, everybody. Perry McLennan here. I am missing my usual partner in crime, Chris Gant Sorensen, today, but we've got a good stand-in. My colleague, Caitlin Beck, who's an attorney with us in our Columbia office primarily, who does immigration work. And Caitlin is going to give us an immigration update today as well, which we like to do every once in a while on these webinars, because I know that there are some of you who have immigration issues with foreign workers, and so we'll get a little bit of an update on where things stand with that, since this is sort of a mid-year employment law update. Just a couple of reminders before we get started. I imagine most of you have been on these before, but for those of you who are new, a little bit about HSB. We are a full service business law firm with locations and practice all over South Carolina, and do work outside of South Carolina also. But we do have 4 or 5 employment lawyers. Also, we run an employment law blog, scemployersblog.com. Please sign up for that. We try to keep everybody up to date on what's happening through that blog, while not pushing too many things to your inbox. We still got our COVID-19 resources page up. Hopefully we're getting to the point in time where we might not need quite as much COVID related advice, but we do still have that resource page up on our website if you need employment or other, insurance related COVID issues. We will have time at the end, I think, if this all goes according to plan, for questions live, if you have them. But please, if you don't mind, go ahead and use the Q&A chat in the Zoom platform to type your questions. We can kind of monitor those and keep a record of them as we go through. While Caitlin is talking about immigration at the end, I may be able to pop into the chat and directly respond to a few, or I may discuss them out loud. Also, if we don't have an opportunity to get to any of the questions, or we need follow-up or something like that, it's good to have a record of those. And as always, the slides will be shared with you following the event. So today's presentation, we're just going to jump around a little bit. It's a mid-year update on kind of what's been going on in the employment, HR, legal world, and of course, COVID is still top of mind. We had a pretty big announcement a couple of weeks ago now from the CDC, coming out and saying that vaccinated employees no longer needed to wear masks inside. Pretty big development. Have fielded a lot of calls from clients the last few weeks about this. I think that, a big reason for that announcement was that, the government at this point is really trying to make a push to get folks vaccinated. And I think the thinking is we maybe can incentivize more people to get vaccinated if we tell them they don't have to wear a mask. Not everyone in the federal government and administration was thrilled about this decision. As you know, the OSHA, the Occupational Safety and Health Administration, along with labor activists, unions, we're working pretty hard on new OSHA guidelines and new OSHA standards for COVID in the workplace. Those standards were going to outline what businesses were going to have to do, and many experts thought that that was going to include masks being mandatory in workplaces. And this just kind of threw everything for a loop. And I think it's a signal that they're trying to get people vaccinated. It's also a signal that we're probably not going to be getting any new standards from OSHA. We may get some guidance, but we're not really sure. As of right now, what we've heard is from OSHA is look to what the CDC is doing. Just so we're clear with what the CDC is doing, they've come out and said that vaccinated employees no longer need to wear masks indoors, and so in the workplace. But they have not changed their guidance as far as unvaccinated persons go. So the CDC is still recommending that unvaccinated persons continue to wear masks. And so, that raises a lot of questions. Okay, so does that mean that we implement a policy where vaccinated persons don't have to wear masks at work, but unvaccinated workers do? Is that the best course of action following CDC guidance? Can we say at this point in time that masks are voluntary for everybody? And if you've chosen not to get the vaccine at this point, that's your personal responsibility. You, of course, could voluntarily wear masks if you want to. All of those questions are kind of popping up as businesses figure out how to, implement a policy at this point. I'll say most businesses, and I say in South Carolina on the slide, because that's where I'm advising most of my clients, and where I'm out and about going to restaurants and things like that, have dropped mask requirements for visitors and customers. I have not been in many businesses across the state over the last 2 weeks since this is announced, and I've been in Greenville, Charleston, Florence, kind of all over, where you're still being required to wear a mask at the business. Some are, but most are not. And so does the same hold true for your employees? Do businesses have to say, okay, nobody has to wear a mask to work anymore? I guess what I would tell you is I think it's still going to be pretty business and workplace dependent on what you do. I would say if you are being conservative and on the safe side, I think what you would probably do is say that masks are no longer mandatory for those vaccinated workers, but for unvaccinated workers, since the CDC hasn't issued any new guidance on that, then those unvaccinated workers still have to wear masks. Now, where does that leave you in treating those two groups differently as far as legal troubles, discrimination, et cetera? Vaccinated and unvaccinated persons, that's not a protected category under law, so you wouldn't be able to make out any type of discrimination claim based on that. And also, wearing a mask is not, an adverse action under discrimination law. So I think that's a stretch. So I think big picture standpoint, I think that you can have sort of two separate policies, one for vaccinated workers, one for non-vaccinated workers. And, we don't know what the CDC is going to do. I mean, the CDC may never drop this requirement that unvaccinated workers, that it's recommended that unvaccinated workers wear a mask. I mean, I don't think we're going to get to a herd immunity point. And so the CDC forever going to say that persons who haven't been vaccinated need to wear a mask? Maybe so. And so the question I think for businesses is, at what point do we go back to sort of things as normal and say, okay, masks are no longer mandatory in the office? And of course, if you feel that you need to wear one, of course you're welcome to, but we're not going to make it mandatory. I think that's an open question. I think some employers have already made the move to say masks are voluntary for everybody. And if you go that route, one thing I would encourage you to consider doing is providing information to all your employees that masks are voluntary, but the CDC is recommending that unvaccinated persons wear a mask. You should know that. You should know that's what they're recommending. That's what we encourage you to do. And if you do not, you are assuming responsibility for, any adverse results of that. If you choose to go that route, I'm not necessarily recommending that, but some companies are doing that. So that's kind of where we are right now with that. I mean, social distancing, kind of the same type of thing. I think you just got to look at your policies and say, are we going to go back to allowing, multiple people to congregate in conference rooms, things like that? I think as a general matter, those are being relaxed across the board, but I would say I would always say sort of be on the safe side, be conservative in what you're relaxing, because what we'll talk about in a minute is this new South Carolina law that says if you adhere to public health guidance, then you're immune from suit from someone saying they contracted COVID because of something your business did. So best practice is still to follow as closely as possible to public health guidance and the CDC. One other thing I'll mention here is checking vaccination cards or proof of vaccination. I've talked to clients that are across the board on this. I know a lot of clients and a lot of businesses have asked for proof. They may want that to see what percentage of the population is being vaccinated. They may want that to enforce mask policies. And I know some businesses have said, we have no desire to ask all of our employees whether they've been vaccinated, and maybe we'll do that, but we have no desire to make them bring their card in. How do we know if they're bringing in a legitimate card, and so on and so on. I think the enforcement is difficult here, but I think that again is going to be very business dependent. A couple more updates on COVID related issues. The Families First Coronavirus Response Act, as you all know, we've been over this a bunch, but it's now a voluntary program. It's been extended through the end of September for those of you that are still paying out that pay. There were in the latest round, there were new reasons added for leave, such as getting missing work for getting the COVID vaccination or recovering from side effects, and or seeking or waiting for a diagnosis. And everybody was reset via April 1st. If you hadn't used it, one question I've gotten a lot, if you hadn't used it before April 1st, you don't sort of get double the amount of time. Everything is just reset as of April 1st. And then you apply the program that way. I will say, if you've elected to participate in this program and pay out people's leave who've missed for COVID related reasons, make sure you're getting the reimbursement through the payroll tax credits for that. Not intended to be an employer expense. Same thing with the COBRA subsidy, which is available from April 1st to the end of September for those individuals that have lost employment through no fault of their own. And again, that's not supposed to be an employer expense. There are tax credits available for that subsidy. And the Department of Labor has model notices that whoever is responsible under the group plan for providing those COBRA information to departed employees is responsible for providing those updated notices. And we just got some guidance from the IRS. IRS notice 2021-31, which contains a lot of information about who qualifies and all of that type of stuff, which I would say for most of you, your plan administrator is going to be handling, but this could come into play for some of you if you handle it yourself through a self-funded plan or whatever the case may be. So just keep that in mind as well. All right. A little bit of an update on where we are in the labor market. I am hearing from so many clients that they cannot find workers. And that is pretty well reflected in the unemployment numbers that are really plummeting. Although it still seems like that there's sort of a disconnect, I think, in the unemployment numbers and how difficult it is to find people to do work. And we're still not sure exactly where a lot of that's coming from, but we do know there's just in general a lot of movement in the labor market. I think that COVID has forced a lot of people to reconsider their career paths, reconsider what they're doing, either because they lost their job or it was just a good time for a reset. But there's just a lot of movement in the labor market, a lot of people quitting, a lot of people looking for new jobs, a lot of people trying new things. And so it's really in flux at the moment. But the unemployment compensation, of course, plays into all that. And we've heard a lot from politicians about that. South Carolina's made a couple of moves on that front. Effective June 30th, individuals receiving unemployment are no longer going to receive the enhanced federal unemployment benefits. States have the ability to opt out of that program. South Carolina is one of many states has now done this. And the idea is that, at this point in time, so many companies are looking for workers that workers should be able to find jobs. And there's no need for that. And, for some lower wage earners, they were, put in a situation where they were potentially earning more money on unemployment than they were working. And that is obviously a disincentive that they did not want. So that is being fixed very shortly. The work search requirements have been reinstated. So it's been during COVID, the unemployment has been a little bit of a free-for-all. There was such a high volume of people making unemployment claims that the Department of Employment and Workforce kind of said, really no way to check this many, verify this many people are looking for work, and conditions are so bad that we're not even going to have that as a requirement. The work search requirements have been reinstated. You got to go on through the portal if you're getting benefits and do the, fill out the 2 searches a week, I think it is, type thing through that. So hopefully that will cut down on that. And hopefully we're improving the labor market, at least in the sense of potentially getting some people off unemployment that were maybe taking advantage of the system. But the unemployment numbers are pretty low. And I think that the tight labor market is probably going to be a continuing challenge moving forward, and is probably an opportunity for some of you to think about what you're offering people as far as compensation, as well as workplace flexibility and those types of things, some of which we'll talk about here in a minute. So one thing I've talked with a few clients about is, okay, we've brought everybody back to the office, or we're phasing people back into the office, and we had a lot of people working from home that are not happy about coming back to the office, and they want to work remote full-time or want to work remotely part-time. And this is presenting quite a challenge. Some of you on the call today, this may not be a challenge for. You may work in a manufacturing environment, maybe, or some other environment where you've all got to be there in the office, and there really are no remote work options. But I think for most of you, at least some of your positions, you theoretically have flexibility to offer people work from home, remote, hybrid options. General Motors made big news probably last week or 2 weeks ago when they came out with their new policy, which they called the work appropriately policy. And the CEO of GM is Mary Barra, and she at least did a stint in human resources, and she borrowed this from the sort of dress code policy of dress appropriately. And I think all of us are familiar with that language as it applies to a dress code. And some companies are applying that to return to work. Don't really know what it means other than it is very position dependent. That you've got remote work options for some positions, not for others, and that type of thing. Making a policy position dependent like that can create issues on itself, of not being treated fairly. Why is this person allowed to work from home? I'm not. I've seen some of that, et cetera. But I think in this tight labor market and in the labor market of the future, in order to recruit and attract talent, you're just going to have to be flexible with that. And if you can find good workers that will only work from home or something like that, then that might be what you have to do. And you may lose people to a company where they feel like they've got a better balance of workplace flexibility. I mentioned earlier how many people were moving around to different jobs. And so keep that in mind. I think that if you are moving for the first time to something of a more permanent work from home, remote work policy, I would encourage you to think real carefully about it and create an actual agreement for those individuals to sign that are working from home. It contains things like confidentiality provisions and clocking in and out pay provisions and things like that, and make sure they know that it's not a term of their employment that's a privilege that can be revoked, all of those types of things. All right, let's talk a little bit about legislation. The South Carolina General Assembly just ended their session, and the big news really was the COVID-19 Liability Immunity Act, which South Carolina was probably a year late in doing as far as our other neighbors in the southern states, but we did get it passed. I've got the primary important portion of the text up there on the screen. And basically what it says is a business that reasonably adheres to public health guidance applicable at the time shall be entitled to immunity from coronavirus claims. When I say coronavirus claims, somebody getting sick and claiming that your business is the reason they got sick. And so back to my point earlier about, following as closely as you can to sort of see, applicable CDC guidance. I mean, I think that's ultimate best practice. And this is one of the reasons why. It does have exceptions for sort of grossly negligent, reckless, willful, or intentional misconduct, or failure to make any attempt to adhere to public health guidance. Hopefully that really won't be in play for you. But, having a written policy that this is what our company is trying to do, I think should cover you, and staying as close to that as you can. This law also makes clear that, to the extent an actual employee claims that they contracted it in the workplace, that should be covered by workers' compensation. And they can't bring a civil lawsuit in court against you. I've seen workers' comp carriers kind of be all over the board about whether they would approve those claims. I know a lot of them are denying claims based on the fact there's no way to actually prove that you got it at work. But that workers' comp exclusion just allows you to not be sued in civil court by your employees. A couple of bills in the General Assembly that did not pass. Senate Bill 177, which would have prevented employers from firing someone who refuses to get the vaccine. This would have been a little bit problematic, I think. I know some companies are requiring new employees to be vaccinated. I think some companies are mandating it. So that would have been, I think, challenging. That they did make an exception for those businesses working with vulnerable populations, like healthcare facilities could still mandate it. But it did allow businesses to encourage, promote, or incentivize, which, seems a little bit counterintuitive in some ways, but that didn't pass. But I wanted to update you on that because I've talked about it before. another bill that would have allowed businesses to publicly promote and display the number of employees who have been fully vaccinated, and would require businesses to disclose it if requested by patrons, which was probably the problematic part of the bill. That did not pass either. One more item that's not on the board that was considered by the General Assembly was the paid family leave for state workers. This would have provided, 12 weeks of job protected, but also paid leave for FMLA type reasons for missing work. That did not pass either, but very well could be passed next time. I think it overwhelmingly passed in the House of Representatives, like 104-4. Governor McMaster said he would sign it, but don't think it made its way through the Senate. That could be one that to keep your eye on, and it comes back around next year. So the federal level, just an update of where we are. We've talked about this, that President Biden's outlined a pretty aggressive pro-labor agenda and proposed a lot of new ideas and changes. He's got the infrastructure plan. He's got the American Families Plan. He's got a lot of big time federal legislation proposed. And as usual, Congress is not moving. The House of Representatives has passed a few things, but it is going to be very difficult to get any big piece of legislation passed in the Senate. From what we understand on some of these bills, they don't even have enough Democratic support in the Senate. There's a couple of very moderate Democratic senators like Joe Manchin from West Virginia that would stand in the way of some of that, and almost no Republican support. So most of the employment activity we're going to see take place is probably going to be at the agency level, primarily at the U.S. Department of Labor. And we've already seen one thing so far this year. Some of you probably heard about this, but the Department of Labor went ahead and withdrew the proposed rule that was proposed under President Trump's Department of Labor, that would have made it easier for businesses to classify workers as independent contractors. I thought this was a good proposal. I've kind of been wanting clarity on this issue for a long time. But unfortunately, when you do things by agency action, they can be easily revoked. That's why it'd be good to have federal legislation on this so we could get one test, because the test is different in every state and depending on what the circumstances are, et cetera. So they withdrew that. So we're back under the test that you're probably familiar with, the economic realities test. It's 7 factors when deciding whether to classify a worker as an employee or an independent contractor. And we're back to that. What President Biden has proposed doing is adopting the ABC test from California, which is very problematic. And the PRO Act, which I'll talk about in a minute, would essentially do that in some respects at the federal level. It's basically what the ABC test is. It presumes that a worker is an employee right off the bat. So all workers, anybody who works for you that you provide compensation for services, they're presumed to be a W-2 employee. And the burden is on the company to show that, to overcome that and show that, no, this person is actually an independent contractor. And under this test, which is what the administration supports, you would have to show all 3 of the following things: that the worker is free from the direction or control of the employer and how they perform the work. Worker performs work outside of the usual business of the company, and that the worker is customarily engaged in an independently established trade. You have to show all 3 of those things to overcome the presumption. And the real problematic one there is that the worker performs work outside of the usual business. So you wouldn't be able to go out and hire a staffing company or something like that to come in and augment your staff performing the same functions that other normal W-2 employees do. The only types of only types of workers that would actually be contractors are, okay, we go out and hire a electrician to come in and fix something at our facility because it's not working. Well, that's not your usual business and providing electrician services. So that worker could be a contractor. Everybody else pretty much be an employee. And so that's that's kind of where we stand right now. That's really the only action we've had. I'll talk now a little bit about the PRO Act, which some of you have probably heard about. I've had a few clients reach out to me to discuss the PRO Act, but it's the most sweeping labor reform bill that we've had really since the New Deal. It has passed the U.S. House of Representatives, but hasn't moved anywhere in the Senate yet, and business groups are pretty concerned about it. Brittany, you can go ahead and move to the next slide. But a couple of things that this bill does, and I don't think you should get too worked up about this bill yet. For those of you in non-union workplaces, because most of its provisions apply to union workplaces, although it certainly impacts non-union facilities as well. But it would override the right to work laws that certain states have, like South Carolina, and it would make wholesale changes to the way that union elections and drives work. For non-union workplaces, I think the important takeaway is it adopts this ABC test for independent contractors at the federal level. And that would sort of establish at the federal level this very, very strict California version of who's a worker and who's an employee and who's an independent contractor. I don't anticipate this being passed. If things change or a watered down version of this bill passes through the Senate or something like that, we will certainly keep you posted on that through our blog and through these webinars. But as of right now, it doesn't look like that's going to be able to move through the Senate. Some of you, this is interesting. Some of you probably followed, and this sort of goes along the same lines as the PRO Act. Some of you probably followed the big union vote at Amazon's Bessemer warehouse down in Alabama. This was a major union vote, the most high-profile union vote that I can remember in a long time, even more so than the ones they've had at Boeing in South Carolina. And labor advocates thought that this was going to be a big victory and sort of a shift in the way people think about unions. And there's going to be the first time that a facility of this size for one of these tech companies like Amazon or Google would have a big portion of their workforce actually unionized. And the union lost in a pretty significant way. So out of the 5,800 workers that were eligible to vote, only 3,215 actually voted. And, that should tell you that, 2,600 workers didn't even care enough to vote, which tells me they didn't really think that there was much difference in having the union there or not. And that kind of means that's bad for the unions. The unions are selling it is that, the workplace can be improved if they're allowed to collectively bargain on behalf of the employees. For the final vote tally, 71% of the votes were cast against it. And that vote is currently being challenged right now. So we'll see what happens with that. There's always legal challenges, but I think it will probably stand. Federal minimum wage. President Biden did sign an executive order increasing the minimum wage for federal contractors. That probably doesn't apply to many of you. It was already, I think it was already at $12 an hour, maybe. But I think across the board, federal minimum wage is unlikely to happen. too much opposition in Congress at the moment to have a nationwide, regardless of size, $15 an hour minimum wage. But a lot of states and local governments have already increased it. Many large businesses have already raised the minimum wage. I don't know many, businesses and facilities that are, paying actual minimum wage. Most are above that. Now, $15 an hour, that's a pretty significant bump, but there's a pretty significant question at this point as to whether it's needed, or should businesses be allowed to sort of do as they see fit. And there are certain geographic regions and certain places where it makes sense. I mean, if you live in Los Angeles, California, you certainly cannot afford to live on $12 an hour, but in certain parts of South Carolina, you may be able to. So the geography is a big part of that. It's looking like that federal minimum wage might have some steam there a while. I was getting a lot of calls from clients, but that's really slowed down. So I don't think that's going to happen anytime too soon. A couple of other quick things before I turn it over to Caitlin. There's a couple of other pay issues. President Biden has urged Congress to pass the Paycheck Fairness Bill in an attempt to close the gender and racial pay gap. This has been talked about for years and is still not going anywhere. Nothing new to really update you on there. One thing that could happen though is because it can be done through agency action at the Department of Labor is they could try to revisit the salary threshold for overtime again. As you all know, it was originally raised to about $50,000 a year, then that was back down. Since they can do that through the Department of Labor, the Biden administration may try to make some changes to that or make some other changes to the FLSA exemption since they don't need congressional approval. So that's one thing to keep your eye on. The only item I'll point out to you is that may have some legs in Congress because it does seem to have some bipartisan support is under Biden's American Families Plan. One of the things he talked about is federal paid leave, 12 weeks of paid family and medical leave, up to $4,000 per month per employee. There's two similar bills making their way through Congress, and paid family leave is an issue. As I mentioned, South Carolina's version of that bill for state employees was passed by the House 104-4. So paid family leave is an issue that has some bipartisan support. The big roadblock to that is Republicans and Democrats generally can't agree how to pay for it. Republicans don't want to increase taxes. They don't want, employers to be on the hook for it. And so Republicans have come up with some creative, like insurance type ways to pay for it. And the Democrats, are more of, okay, we'll fund this through either tax increases or have it be an employer expense. That is one that, again, we'll keep you posted on that, but that's one that actually could get some congressional approval if they can agree on how to pay for it. One very, very last point on, and Brittany, you can advance the slide to the next one. Yeah, there you go. For one very last thing, and I just threw this in there because I found it interesting. I saw it on LinkedIn. I shared it through my LinkedIn, but I don't know if any of y'all have been following this, but Basecamp is a software company, and they have their CEO issued a big memo that they are outlawing political discussions at work. They said that I'll read this here. He says that today's social and political waters are especially choppy. Sensitivities are at 11, and every discussion remotely related to politics, advocacy, or society at large quickly spins away from pleasant. You shouldn't have to wonder if staying out of it means you're complicit or wading into it means you're a target. These are difficult enough waters to navigate in life, but significantly more so at work. It's become too much. It's a major distraction. It saps our energy. and redirects our dialogue towards dark places, it's not healthy. I basically said, we're not here to be talking about politics. We've got a business we're trying to run. We're not talking about larger societal issues, which I, understand. That there was sort of an employee revolt against this, and they had 20 people, which is roughly about a third of their workforce, quit over this. And maybe they wanted to weed out some of those individuals. I think they actually offered severance packages to anyone who felt like this was inconsistent with their values and wanted to leave. But thought that was interesting. It'd be interesting to follow what other organizations do with that. And so I just threw that in there, but I'll be happy to answer questions at the end, but I'll turn it over to Caitlin to do, just give us a little bit of update on where we stand on immigration.
Thanks, Perry. And hi, everyone. Like Perry said, my name is Caitlin Beck, and I practice business immigration here at Haynsworth. I practice with Garrett Steck. We do primarily employment-based visas, H-1B visas, and then any family visas that are that follow those. So we'll go ahead and dive into probably what's going to be the most relevant for you all today on what I'm going to be talking about. And that's the I-9 employment eligibility verification form. I'm sure you are all very familiar with this form. And back in March of 2020, as you all probably do know as well, the federal government waived that physical inspection aspect of this form. And so I'm talking about Section 2, where you have your passports, your social security cards, your licenses, and you have to have that employee physically come in and inspect those documents with them there. With you. The federal government waived that aspect of it until March 31st of this year. And then on March 31st of this year, that flexibility policy, as they're calling it, was extended until May 31st of this year. Now, I know May 31st is just a couple of days away. I fully expect that they're going to do another extension of this. They didn't announce the extension that we're in now until the day it expired on March 31st. So definitely look for that. There's a high chance on May 31st they're going to go ahead and extend this. So just a couple of things on this. As I said, I'm sure a lot of you are pretty familiar with this point. This applies exclusively to your employees that are working remotely. If you have employees that are coming in on that, the threshold's kind of this regular, consistent, or predictable basis, they still need to report to the employer. And within 3 days, you all have to do that in-person verification. Next slide, Brittany. And so just one more slide on this, just to kind of talk about the importance of documenting this, which again, I'm sure you all know the importance of documenting everything that you're doing. The employers, if you're choosing to exercise this waiver and not do the physical inspection aspect of this form, definitely make sure to document that employee's entire onboarding, remote onboarding, and then also document the telework policy that you have. That's really important, just to make sure you keep that in that file. And then also you still do have to inspect those documents remotely. So even though they don't have to physically come in, still do a Zoom call with them and inspect those documents remotely. Once the employee does come back and is working in the office on that consistent, continued, predictable basis, that is when you will do that physical inspection. And when you do that physical inspection, it's really important to note the reason for the delay. And that's going to be on Section 2 of those I-9 forms. There's a little block that says additional information. Just make sure to write the reason for the delay was COVID, and then that you have physically inspected all the documents, and then put the date there. And then that in-person completed date will be used if by chance you're audited. So those are just some things to keep in mind when waiving that physical inspection. And also just something to note too, I know Harry had kind of discussed maybe after this, employees are going to start looking at remote working being more permanent. If they do go ahead and extend this, I would go ahead and do that physical inspection, even though you still have this option, unless there's a reason why that person can't actually come in. So I just wanted to kind of note that and follow up on something Perry said. So Okay, so the next thing we're gonna talk about is international travel. There might be some of you who have business visitors trying to get in on business visas to come and visit the company or do anything with the company, or just people you're trying to get over here on certain employment visas or H-1B visas. And like the rest of the world, there's been travel restrictions into the United States. So in January of this year, President Biden said that all non-US citizens, so this excludes green card holders, who are traveling to the US, but were present in certain countries 14 days prior to traveling to the US, are going to have travel restrictions. And I've listed the countries you can see here: China, Iran, Brazil, UK, Ireland, South Africa. India was just added, and 26 areas of the Schengen area, which is Europe. So if anybody is trying to come over to the United States for any reason, and they have been in any of those countries for 14 days prior to, they're going to hit a ton of roadblocks. So something that the federal government did to kind of work around this, knowing that there are some people that need to get around that, is the national interest exception. And so this was created as an exception to travelers who have their entry is of national interest. And that's going to be academics, so a lot of teachers, some students, but probably most important to this group, a national interest exception can be applicants that can provide evidence that their entry to the US provides significant contribution to critical infrastructure sectors or related supply chains. And so that's going to be your emergency services, healthcare, public health, energy, transportation services, commercial facilities, information technology. So if you have anybody that you're trying to get here that's going to run into this travel restriction, and you think they might fall into this natural interest exception, just kind of remember there's this pretty wide, or this pretty expansive list of people who, if they can provide evidence that they're a part of those infrastructure sectors, they may be able to get around that. And please feel free to contact me. We're happy to kind of talk that through with you. And then the last thing for international travel, that's really been just the biggest kind of issue with international travel, is that in March of 2020, the US closed, almost all of its embassies and consulates worldwide, and sort of reduced their services to emergency visa services. So they suspended routine visa services, and that has created or made it impossible to travel truly. And so right now, there's still more than half of the embassies are closed or partially closed, and they've been trying to kind of prioritize these non-emergency visas, but still just a ton of backlog, which we'll talk about next. And then the reopening of these visa or these embassies and consulates is really unknown. I mean, it's just going to have to be dependent on where the global pandemic goes. Hopefully with the vaccinations, they'll be open soon, but we'll have to see on that. So, and then the last thing we'll talk about today is just the Biden administration and kind of what the proposals that Biden has, some of his proposals that he's had, and maybe what's coming down the pipeline and what he's done. So there is a truly unprecedented backlog right now of visas and green cards. There's always a backlog, without a doubt, but right now it's unbelievable. And it's due to the Trump administration had some pretty intense restrictions on immigration, and then just COVID. I mean, it's just created enormous backlogs. So the Biden administration, some of his immigration policy goals have been to roll back some of these Trump administration policies that he believed were creating this backlog. One of probably the biggest ones that is sort of maybe relevant to this group, if you have employees that are trying to get green cards, or I guess friends and family, but mostly employees that are trying to get green cards, is the Trump administration had put in what was called the public charge to the green card applications. And this was a whole separate sheet, and you had to fill out whether or not your income, your credit score, whether or not you've been bankrupt. And basically it was kind of to gauge the immigrants' potential use of public benefits. And so that created a significant amount of backlog, and some people thought it was just simply unnecessary. So Biden has scrapped that. Trump had also proposed wage increases for the H-1B visas. You kind of had to prove that they were going to have a higher wage than what they had before. And that was just a proposal, but Biden has also scrapped that. That's a lot of other policies that have to do with asylum and that, but obviously that's not as relevant here. And so for the Biden administration proposals, I mean, Perry mentioned this before, it's really hard to push anything, all the way through Congress into law. And it's definitely really hard to push any type of immigration reform. So we'll have to see where any of his proposals go. I don't have a ton of hope for some of these, but we'll see. I mean, we'll just have to see what happens. He has proposed to increase the employment-based visas and eliminate the per country gap. So right now there's 140,000 employment-based visas that the US gives out. And then each country can only take 7% of that total number. And so there's lots of talk of completely scrapping that per country cap of 7%. And there's talk of increasing that total number of 140,000 employment-based visas that we hand out. There's also talk of increasing the number of diversity visas. This is often called the visa lottery. This goes out, we give 50,000 of these out. Biden has proposed that we bump this number up to 80. There's always the issue of pathway to citizenship. This is, of course, for the illegal immigrants in the country. This is a topic that has been in Congress for, as you all know, quite some time now. Whether or not this will even get pushed in any way, but we'll have to see. And then lastly, expanding access to family-based green cards. This is going to be family members of those people that receive the green card, just expanding access to them to be able to come along with that primary beneficiary of that immigration benefit. So that's kind of all I have for the update on immigration law. Feel free to reach out to us. We're happy to help answer questions.
Thank you, Caitlin. That was very helpful. Thanks for joining us and giving us that update. We appreciate it. Well, we're almost at an hour, and so we don't have much time, but I am happy to answer any questions anybody has if they want to speak up or still ask a question in the chat box, in the Q&A box. I did see one question in there, which somebody asked, asking about how a law affected a home care agency, and I wasn't sure, since I didn't see it until after I finished talking, which law you're referring to. So feel free to reach out to me separately if you want to follow up on that question. But not hearing or seeing any other questions. Thank you again for joining today. Hope everybody has a great long Memorial Day weekend and maybe can start it early. Thanks, everybody.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.